So I want to spend a few minutes talking about some of the things we talked about in class yesterday, but this one dealing most importantly with the complaint being used in justice and municipal courts. Now, you have to do historical research on this to understand this from this perspective. Once you've read all the case opinions, once you've read how these judges have gone back and done their historical research, or more aptly, how their clerks have done it, you will come to understand that they will write an opinion any way they want, regardless of how weak the support for their position is. And you can tell when they know they're operating from a weak position, because they will hang their hat on one single nail of an argument, even though there are 6 that say that argument is wrong. They will completely ignore those 6 as if they don't exist, just so that their one will stand up in the light they want to cast it in. And nowhere does that become as obvious as in understanding the issue of the criminal complaint. Now, what I want to do is I want to read you the provision of the Texas Constitution where this entire argument is based. And it is ludicrous that they have not reasoned this out beyond the point that they have, especially considering the number of years this has been going on. But it is Article 5, Section 17. If I'd get in the right section or right article here, I might actually be able to show that. Article 5, Section 17 of the Texas Constitution, which is, of course, the Judicial Department article. And we go down to 17, and this is what we read. Well, hang on, we'll get there in just a second. They keep changing the online stuff and moving it around. All right. Section 17 of Article 5, terms of county court prosecutions and juries. The prosecutions provision is what interests us the most. But listen carefully to this. The county court shall hold terms as provided by law. Okay? That's terms of court. That's the only line dealing with what's in the title for terms of court. The second is prosecutions, which is this line. Prosecutions may be commenced in said court by information filed by the county attorney or by affidavit, as may be provided by law. Now, what the courts are trying to say is that the affidavit in this case is the criminal complaint. Now, here is the problem with that argument. First off, you have to understand what an affidavit is and what an affidavit isn't. A document can only be a proper affidavit if it meets several specific legal criteria as set forth by the courts. A couple of those criteria are, 1, it cannot contain any qualifying statements, such as the affiant is of the opinion that, or the affiant believes that, or the affiant thinks that, or the affiant understands that. None of those will be sufficient in an affidavit for it to comply and be a valid affidavit for the purpose of submitting it in a court. Another element of an affidavit is it must be signed in the affiant section. The signature for the affiant must be someone with personal knowledge of the facts being attested to in the affidavit. Okay? The person signing the affidavit as the affiant must have personal first-hand knowledge of the facts being asserted. An affidavit also must be sworn under penalty of perjury. Now, here is where we run afoul. With just those 3 elements, we immediately run afoul of the issue with a criminal complaint being the affidavit spoken of here. even though the criminal complaint is signed by an affiant and there is a verifier, the verifier is not verifying that the person is swearing to the facts in the complaint. They're verifying that the person who signed it is the person who signed it. How do we know this? The other criteria. A criminal complaint contains the language, I have reason to believe and do believe. Those are qualifying statements. Those are not allowed in affidavits. The second problem is the affiant in a criminal complaint is not required to be someone with personal knowledge of the facts being asserted or the facts being alleged. Because the facts are not facts if they're hearsay. Therefore, all they're doing is repeating what they've been told. They don't know if they're true. They can't say that they're true. So a complaint, right off the bat, is nowhere near compliant with the three major requirements of an affidavit. So this affidavit spoken of in Article 5, Section 17 cannot possibly be a criminal complaint as that complaint is created, constructed, and used in Texas jurisprudence. So what affidavit is it? Well, what other statement is signed by someone in a criminal case that would meet the requirements of an affidavit? The criminal statement would. When you go down and make a police report to the police department, you have to sign it under penalty of perjury that the facts asserted are true and correct and that you yourself have knowledge of those facts. You have to have personal first-hand knowledge of what you're attesting to. So the verified criminal statement of an actual witness, that would be a valid affidavit. But that's not what they're using to make the complaint. 99% of the time, a clerk of the court is the one that signs as the affiant. They have no personal first-hand knowledge. They cannot attest that the facts asserted in the complaint are true and correct because they copied them off of a citation or they wrote them down when someone else was telling it to them. And that someone else isn't signing the complaint as the affiant. Why not? Even if the officer signed the complaint, it's still not an affidavit. You know why? Because the complaint is not required to be signed under penalty of perjury. Plus, it contains the qualifying statements, I have reason to believe and do believe. Now, why am I talking about this and why is it even important? Well, it's important for several reasons. It's important, one, because the courts are all arguing that in a Justice and Municipal court, the complaint by itself is sufficient to invest the court with jurisdiction of the case, when Article 5, Section 12B of the Constitution doesn't say anything at all about criminal complaints. And in fact, Article 5, Section 17 doesn't say it's a criminal complaint. It says it's an affidavit, since we just proved a criminal complaint isn't. So right off the bat, we've got an issue here. So y'all hang on, folks. When we get back, I'm going to finish this discussion up and start taking our phone calls if we get people up on the board. 512-646-1984. We will be right back. All right, folks, we are back. Now, besides those issues of why the complaint not being this affidavit in the Constitution is a problem, like I said, they're saying that that complaint is what invests the Justice and Municipal courts with jurisdiction, which flies in the face of Article 5, Section 12B. It also flies in the face of this other part of Article 5, Section 17. Now listen carefully. Grand juries impaneled in the district courts shall inquire into misdemeanors, and all indictments therefore returned into the district courts shall forthwith be certified to the county courts or other inferior courts. Well, what are the county courts underneath the district court? They are the county court at law and the constitutional county court. This is talking about plural, So it's not meaning one or the other in that regard of county court or constitutional county court or county court at law. Okay? It's encompassing them in its plurality of the statement. What gets us is, or other inferior courts. Then you go read Chapter 20 of the Code of Criminal Procedure dealing with indictments, and it specifically tells you that a district court that hands down an indictment to a justice court, exactly how they're to do it. Now, it doesn't mention an indictment going to a municipal court. Why do you think that is? How can it be a requirement to have an indictment for a Class C fine only in a municipal court or in a justice court, but not the same in a municipal court? And if it's not required, why in the case of Antonio Buehler did they indict him for a Class C misdemeanor and try him in the Austin Municipal Court? Because they did get an indictment against him and then tried the case in the Austin Municipal Court. Now, if they're screaming and hollering that an indictment is not required for misdemeanors, why did they do that? Why does Chapter 20, which everything in Chapter 20, by the way, was enacted in 1965. 1965, okay? The amendment to Article 1, Section 10, which allegedly removed the requirement for a grand jury indictment for misdemeanor cases that did not require incarceration in a state penal facility, is now in direct conflict, as I've told you before, with Article 5, Section 17 right here, and Chapter 20. The amendment in Article 1, Section 10 was in 1909. Chapter 20 was added in its entirety in 1965, is when it became active. So that means it was actually passed in 60, well, it would have had to have been active at some point in 65, because they only meet in the odd number years, and they'll set it up to go into effect over those years. So the actual bill was either enacted in 1963 and didn't take effect until 65, or it was enacted earlier in 65 to take effect later in 65. But why, if it was not a requirement under the Texas Constitution any longer, would they require it in the statute in 1965? Okay? What is it? 54 years later? Or 56 years later? So, but now, listen to this again, real careful here. Okay? Dealing with the grand juries and all indictments therefore returned in inferior courts, blah, blah, blah. But where it says prosecutions commenced in said court by information filed by the county attorney or by affidavit as may be provided by law. That's the thing. As provided by law. That means that the legislatures granted constitutional authority to set the requirements for indictments and informations by the statutory laws, which they did in Chapter 20. They also did it in 2.04 and 2.05 of the Code of Criminal Procedure, not just Chapter 20. There has never been a statute in the Code of Criminal Procedure that says a complaint invests the municipal court with jurisdiction. There's nothing that says a complaint invests the justice court with jurisdiction. That determination is made entirely by the courts. But the courts have been ignoring 2.04, 2.05, Chapter 20, and this particular analysis of Article 5, Section 17, where the affidavit cannot possibly be the criminal complaint. So you add all that up, and what do we have? We have unlawful, unconstitutional convictions taking place in justice and municipal courts without benefit of a proper indictment of your peers at the grand jury level, or a proper charging instrument which are the only two instruments that invest a court with jurisdiction to try a case. Now, why would the courts keep insisting to protect the way they've set this up? Well, let me make that easy to understand. They're wrong. The lower courts acted in every single instance without proper jurisdiction of any kind. They were completely devoid of jurisdiction because no indictment or information was ever filed in the case. Every conviction they have made was illegal, unlawful, unconstitutional, and no court has immunity for any act it takes upon itself if they don't have jurisdiction to perform the act. The lawsuits would be staggering in number and mind-boggling in dollar loss to the state. All because some judge wanted to shortcut the due process rights of the accused to get their money faster. Can you imagine that? Can no one out there believe that the courts would stoop to such a procedure, considering how they're ruling on everything right now? Surely that couldn't be the case, right? Surely our courts are there to protect our rights, not ignore them. Right. You obviously haven't been spending a whole lot of time awake in America. You've been in a coma somewhere if you actually believe that. Because the courts don't function for you and me. They haven't for a very long time. Okay? Haven't at all. But no one is noticing. Why do you think that is? Because they think this couldn't be the way it works in America. This is America. No, folks, you don't live in America anymore. You live in America by name only, but certainly not by law, not by Constitution, not by rights do you live in America, because none of that is recognizable here anymore. Who's to blame? Well, first, the people are. We let this happen. We didn't say no. We didn't hold anyone accountable. That's our fault. But who is second in line to make it operate this way? Well, besides the corrupt individuals throughout government, we can honestly blame most of our problems on lawyers. And we can do it without any caveat whatsoever. You know why? Because lawyers are the ones that invented this system as it exists today. Lawyers are the ones that have chiseled it out of the mud and crap that they've put together to call the justice system. And then they've manipulated it to such a way that they can make it mean anything they want, any time they want, for any purpose they want, in any kind of case that they want. And that's a problem. You know why it's a problem? Because we're the ones paying the price for it, and we're letting them get away with it, and they're stealing everything